Have you ever wondered what actually stops the government from searching your phone? Or what guarantees your right to protest? We hear the terms civil liberties and civil rights thrown around constantly in the news, but they aren't the same thing. Today, we are breaking down the Bill of Rights, the key differences between liberties and rights, and the landmark Supreme Court cases that define them. Let's dive in. First, let's define our terms. Think of civil liberties as a shield. These are specific protections from the government. Their main goal is to ensure your individual freedoms and personal autonomy remain intact. A perfect example of this is freedom of speech. The government cannot pass a law that simply silences you because they don't like what you have to say. On the other hand, civil rights are protections by the government. Instead of a shield against the government, this is the government acting as a referee to stop discrimination and ensure everyone gets equal treatment. The classic example here is voting rights. The government actively steps in to ensure no one is denied the vote based on their identity. So where do these protections come from? Most of our civil liberties are found in the Bill of Rights, the first 10 amendments to the Constitution ratified back in 1791. Originally, these were written specifically to limit the power of the federal government and protect individual liberties. The founders were very worried about a central government becoming too powerful. But here is a crucial plot twist. Originally, the Bill of Rights didn't apply to state governments, only the federal one. That changed with something called selective incorporation. Through the 14th Amendment, the courts have slowly applied these rights to the states as well. This means your state governor has to respect your free speech just as much as the president does. Let's jump into the First Amendment, starting with freedom of religion. This is actually a two-part protection. First, we have the Establishment Clause. This prevents the government from supporting, endorsing, or creating any official religion. It is the constitutional foundation for the separation of church and state you often hear about. The second part is the Free Exercise Clause. While the government can't force a religion on you, they also can't stop you from practicing yours. This clause protects your right to practice your faith without government interference or restriction. Whether you go to a church, a mosque, a synagogue, or nowhere at all, that choice is protected. Moving on to perhaps the most famous liberty, freedom of speech. It's not just about spoken words. The Constitution protects symbolic speech too. This includes things like what you wear, the flags you might wave, and even campaign finance contributions, which are considered a form of protected expression. However, free speech is not absolute. You can't say whatever you want without consequence. There are strict limits. These include libel and slander, which are lies that hurt someone's reputation, and obscenity. Also, speech that creates a clear and present danger, like using fighting words that incite immediate violence, is not protected. A massive test of free speech happened in schools with the landmark case Tinker versus Des Moines in 1969. In this case, students wore black armbands to school to protest the Vietnam War. The school tried to ban them, but the Supreme Court stepped in. The court ruled in favor of the students. They famously established that students do not shed their constitutional rights at the schoolhouse gate. The ruling affirmed that students have free speech rights unless their expression materially disrupts the educational environment. Basically, as long as you aren't stopping class from happening, you have a right to express your opinion. Next up is freedom of the press. The media is often called democracy's watchdog. To do their job, they need independence. A key concept here is that prior restraint is prohibited. This means the government usually cannot censor a story or stop it before it gets published, even if they really don't want it out there. This was put to the test in New York Times versus United States. The Nixon administration tried to stop the New York Times from publishing the Pentagon Papers, which were classified documents about the Vietnam War. The court ruled in favor of the press, affirming that the government couldn't block the publication, reinforcing the heavy burden against prior restraint. The First Amendment also covers your right to assembly and petition. This grants citizens the right to peaceful assembly and to gather for protests. However, the government can regulate the time, place, and manner. For example, you have the right to protest, but maybe not at 2 a.m. with megaphones in a quiet neighborhood. Connected to assembly is the right to petition. This allows citizens to formally complain to the government and seek redress, which is a fancy way of saying fixing the problem without fear of punishment. If you don't like a law, you are legally allowed to tell the government about it without going to jail. Now we move to the Second Amendment, the right to bear arms. This is one of the most debated sentences in the Constitution. The text references a well-regulated militia and the right of the people, creating a long-standing debate. Is this a collective right for a militia or an individual right for a person? The Supreme Court clarified this debate significantly in 2008 with the case District of Columbia v. Heller. The court affirmed that the Second Amendment protects an individual's right to own firearms, specifically handguns, for traditional lawful purposes, such as self-defense within the home. Finally, let's look at the Fourth Amendment, which covers search and seizure. This is your protection against unreasonable searches. Generally, for the police to search your home or property, they need two things: probable cause, a good reason, and a warrant signed by a judge. Without those, the search is usually illegal. What happens if the police break the rules? That's where the exclusionary rule comes in, established by the case Mapp v. Ohio. This rule states that evidence obtained illegally, without a proper warrant or probable cause, cannot be used against you in court. It removes the incentive for police to cut corners. However, if you are a student, the rules are different. In New Jersey v. TLO, the court ruled that school officials do not need a warrant or probable cause. Instead, they only need reasonable suspicion, which is a much lower standard. This allows schools to maintain safety and order, meaning your locker or backpack is less protected than your home.